Gift and a will are both transactions which are done without any consideration. Okay, where a person who is the owner of the property chooses by his voluntary volition to transfer the property in favor of somebody else. Now, the beneficiary of that transaction, which in a gift it is called as a donee, whereas in a will we call it as a bequest. Okay, or a beneficiary will get the property without any monetary consideration. The key difference between a gift and a will is that a gift comes into effect immediately. The transfer happens when the donor executes and registers a gift deed in favor of the donee, or if it is and hands over possession, or if it is a movable property by simply handing over the property to the beneficiary. Whereas a will comes into effect after the lifetime of the person who is making the will, which we call as the testator of the will. Now, in a gift also, there is a provision where a donor, who is the owner, who is making the gift, can retain a life interest to himself. That is, during his lifetime, he will be able to enjoy the benefit of that property, either by way of holding the physical possession of the property. If he is, say, it is a residential house where the donor is residing, he could retain a life interest in his favor, which will entitle him to continue residing in that property during his lifetime. And the donee will get actual physical possession after the lifetime of the donor. But the transfer has already taken place. The donor does not have legal ownership over the property, but only a life interest. The challenge here could be that if during the lifetime of the donor, the donee has some disputes and they are no longer in good terms and decides to dispossess the donor, or then it will lead to a legal fight. Okay, because the donor no longer has the legal ownership over the property. Whereas in case of a will, the donor will continue to have absolute ownership of all the properties during his lifetime. He can also choose to change a will. Whereas in case of a gift, once the gift is registered, the donor cannot unilaterally cancel the gift. It has to be done by the action of both the parties. But a will can be changed at any time during the lifetime of the person who is making it, and he continues to retain ownership over the property. But the challenge, practically, as we have seen in many cases, is a donor is that a person after making a will may not be in a state of physical or mental fitness that will allow him to manage the property. In which case, because the law in India still does not recognize a living will, so the management and custody of the property may pose a challenge unless one has clearly contemplated and provided for it in the will itself.